Okay, so one of the things that you do, I know, is you're sometimes a minor's counsel.
Yes.
Could you explain what that is? Because I know when we first heard in different parts of the country, in different parts of the world, we say guardian ad litem, minor's counsel, attorney for the child, and we thought, oh, it's probably about the same thing, but it's not, right? Can you tell us what the difference is?
Well, so California has a law that says, it's called Family Code 3150, and that law describes what minors counsel should do. So minors counsel are lawyers who get appointed to represent kids. We get paid, but we get paid by the state or the county, and it's far less than our normal hourly billing rate. And our job, at least under California law, in theory, is to just be a lawyer for the kids. In other words, we're not witnesses. We're not supposed to make reports. We're allowed all the same access to information that parents are allowed access to, and not really any more than that. We're really just lawyers in a case, a third lawyer who's supposed to put on a trial. And that was the rule until the case was Ramsden versus Peterson, which is a case that I argued unsuccessfully to the appellate court, that said that our minors counsel was making recommendations in a case. I was not. I was a lawyer for one of the parents, and we tried to stop her from making recommendations under the theory that she's not an expert, that she's not trained to make recommendations, that what she's really good at doing is being a lawyer. And if she's listening in, I want to say she's a very good lawyer. But I didn't think at the time that she was an expert who could be a witness in a case. And it says you're not supposed to be a witness. The appellate court affirmed the trial court's ruling, basically saying that lawyers for children could make recommendations. And that has kind of created a blurry line between what I think of as a traditional guardian ad litem, who is a witness. That guardian ad litem goes out and writes a report and comes back and tells the court, this is what we should do under the circumstances, whereas a lawyer is just supposed to argue. And we don't have to find information, we just get to present it. And I think now there's a blurry line in California, and it's kind of gummed up the works a little bit. I have a lot of lawyers who are pretty upset about this decision.
Yeah, so if you're an attorney, I'm thinking in my head, it sounds like minors counsel is what in New York is called an attorney for the child, which again is appointed by the court. It's neutral in terms of like, it's not like one parent is paying the salary and could influence it.
Right.
So, so you're in a little bit of a bind though, when a minors counsel does this kind of work, right? Because talk about best interests.
Yeah. So one of the issues that as a lawyer, it's typically really easy. When I say easy to do my job, and what I mean by that is it's easy to work with my client, find out what they want to have happen, and advocate for that. That doesn't mean I won't advocate with my client to say, hey, I think your position is too strong. I think that this isn't something I think we should ask for, and here's why. I might have a back and forth with my client, but once we've understood what the advocacy position is, then we're like and I'm sure your listeners all know, we're like a wind-up doll, right? We just point us in a straight line and we just keep going, right? That's advocacy. But as a lawyer for kids, you kind of have.
Oh, Jude, I think we lost your volume for a second. Can you hear me?
My phone was ringing.
It always happens. Okay, say again. So as a lawyer for the child,
you sort of have two hats, because you have a client, and the client has an interest, and that interest might be I want to live 50-50 with both parents, and that's what they tell you, right? And so we're trained as advocates to want to do the thing that our client wants us to do, but the law also asks us to look at the best interest of the children, and this is what I don't know if you say guardians ad litem. I think that's what you say instead of guardian ad litems. But guardians ad litem do that. They're supposed to figure out what the best interests are of their ward, and then they write reports. They advocate for that. That's all they do. But they're determining the best interest. They may have discussed it with their client, but in the end of the day, they're going to make the decision. That isn't really what we're asked to do, or what is partially what we're asked to do. But we're also balancing that against pure advocacy, which is what does our client want? And so, if you're interviewing a stressed out 11-year-old who's got one parent lives in Los Angeles and one lives in Paso Robles 4 hours away, and they're trying to go every other weekend back and forth and spending 8 hours in the car, but they tell you I want to see both parents a lot, but I'm also really stressed out about being in the car. It puts a bind on the person who's representing the child, because on the one hand they're not really old enough to speak for themselves at 11. The law recognizes 14 in California, but maybe 12, but probably not 11. So on the one hand, you want to advocate for what they want, which is time with both parents. On the other hand, you're balancing that against twice a month doing an 8-hour drive with a stressed out parent, which makes the drive even more stressed out. And how do we do that? So I think that it's a little bit challenging. I did look up under Florida law, they call it attorney ad litem versus guardian ad litem. And so it might be that they're kind of blurring the line for us, I guess, but saying we should both act as a guardian ad litem and act as an attorney for the child. And I think that creates a conflict.